We've got some truly monumental Second Amendment news breaking out of the Commonwealth of Pennsylvania. And let me tell you, this isn't just another legal footnote. This one lands like a hammer. A major state-level appeals court just overturned a key part of Philadelphia's long-standing anti-gun policy. And the shockwaves from this ruling are going to be felt coast to coast. We're talking about a local ordinance that's been used for years to charge ordinary, peaceable citizens for doing nothing more than carrying a firearm where others could see it. No threats, no violence, just legal open carry, now officially deemed unconstitutional. Stick with me, because I'm going to walk you through exactly what happened, why this matters far beyond Pennsylvania, and why anti-gun lawmakers everywhere just got a serious wake-up call. Here's the full picture. A man named Mr. Sumpter was walking down a public sidewalk in the city of Philadelphia, just like thousands of responsible Pennsylvanians do every single day, head on a swivel, minding his own business and taking personal responsibility for his own defense. He had a legally possessed sidearm tucked into his waistband, partially visible, peacefully carried. He wasn't threatening anyone. He didn't commit a crime. There was no confrontation. He was simply exercising what he believed was his natural and constitutional right to bear arms. But because he was inside the Philadelphia city limits, and only because of that, he was treated like a criminal. Law enforcement saw the firearm, stopped him, and placed him under arrest using a city-specific statute called Section 6108. That's where the problem starts. You see, this law makes it a criminal offense to openly carry a firearm within the city of Philadelphia unless you've got a license to carry. But, and this is critical, the very same act is entirely legal in every other county across the state for any law-abiding adult over the age of 18. The law doesn't target the action, it targets the location. Had Mr. Sumpter been just a block or two outside of the city border, he never would have been detained, let alone arrested. But thanks to this invisible legal fence surrounding Philadelphia, the mere act of openly carrying a handgun became a prosecutable offense. That arrest turned into a conviction, and that conviction kicked off a legal challenge that has now reached a defining moment. What started as a quiet local arrest has become a landmark legal fight. And because Mr. Sumpter chose to stand up rather than roll over, because he pushed back in court instead of taking a plea deal, the court had to face an uncomfortable reality. This law isn't neutral. It doesn't treat citizens equally. And when a statute creates unequal treatment around constitutional rights, it cannot stand. Now here's the part that hits hard. The appellate court didn't sidestep or soften their language. In a ruling that landed like a granite block, the court dug into Section 6108 and called it what it truly is, an unconstitutional rule that unfairly singles out people in Philadelphia for second-class treatment under the law. The judges made it clear, the Constitution is not conditional based on geography. The Equal Protection Clause of the 14th Amendment guarantees that individuals in similar circumstances are entitled to the same legal protections. This law, instead, carved out a special group, anyone living in or walking through Philadelphia, and stripped away rights that every other Pennsylvanian is free to exercise without question. The court came right out and said it. In the Commonwealth of Pennsylvania, open carry is perfectly legal for any adult over the age of 18 unless you're in Philadelphia. Step inside that city line, and suddenly the same exact behavior becomes a felony offense, unless you've gone through a whole separate maze of licensing requirements. That's not just arbitrary, it's the textbook definition of unequal protection under the law. And when the judges applied strict scrutiny, which is the highest level of constitutional review, the state had nothing solid to offer in its defense. The government tried the usual play. They pointed to crime rates in Philadelphia and argued that the city needed special rules to keep people safe. But the court wasn't having it. They made it very clear that fear, even fear of gun violence, can't cancel out a basic, fundamental right. Judges don't get to reinvent the Second Amendment every time a city gets nervous. That balancing act between liberty and public safety? That was settled a long time ago by the founders when they wrote the Second Amendment into the Constitution. The ruling leaned heavily on landmark decisions like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin. And the message was clear as day. A city doesn't get to suspend your rights just because it's more densely populated or has higher crime. If that were allowed, then every city in America could carve out its own version of the Second Amendment, or worse, declare it null and void altogether. Rights don't magically disappear when you cross from a suburb into a city block. The judges nailed it when they said that Section 6108 put Philadelphia residents at a special disadvantage when it came to exercising a core constitutional liberty. And that phrase, special disadvantage, is going to echo in the courtroom for years to come, because it captures something gun owners across the country have been saying for decades, that some cities have used local ordinances to sidestep the Constitution, using public safety as a smokescreen for control. But this time, the court didn't flinch. They called it what it is, ruled the statute unconstitutional as applied, and reminded everyone that the Bill of Rights doesn't get overwritten by local zoning laws or city hall politics. And here's what makes this ruling so significant: it didn't rely on fringe legal theories or stretch the law to reach some ideological end. It was grounded in the basics: equal treatment, constitutional history, and plain text. The judges simply did what they're supposed to do. They looked at the precedent, applied the existing standard, and let the law stand or fall on its own merit. Section 6108 collapsed under that scrutiny. That's why this ruling is such a massive blow to the anti-gun lobby. They can't accuse the court of judicial activism here. The bench didn't make up new rules. They followed the roadmap set out by Heller and Bruin. They studied the legal history, applied the proper standard, and Section 6108 didn't survive the test. One of the most powerful parts of the opinion was when the court directly acknowledged that the law created a special disadvantage for folks in Philadelphia just trying to carry legally. That kind of legal language isn't thrown around lightly. It opens the door to future challenges against other city-specific restrictions that discriminate based on nothing more than location, income level, or population density. And let's not forget, the court didn't brush aside Philadelphia's public safety argument. They dismantled it. The judges flat out reminded the state that the time to weigh freedom against fear passed over 2 centuries ago when the American people chose liberty and ratified the Second Amendment. That decision has already been made. Modern courts don't get to rewrite it just because somebody behind a desk in City Hall wants to feel more in control. This ruling is more than a local victory. It puts backbone back into the Second Amendment. It says that your right to carry doesn't shrink just because skyscrapers fill the skyline, or because a local council thinks you should feel safer without it. This wasn't about one man. It's about the millions of city-dwelling Americans who've been told, directly or indirectly, that their rights don't apply past the city limit sign. Now they've got judicial backing. Now they've got precedent. And now, that legal tide is starting to shift. For years, major cities have been playing a dangerous game. They write carve-outs, pass targeted laws, and create loopholes around fundamental liberties, all while pointing to crime stats and hoping the courts will look the other way. Philadelphia, New York City, Chicago, San Francisco, they all follow the same playbook: push the envelope, test the limits, and expect immunity because they're urban. But this Pennsylvania ruling just flipped the board. Section 6108 is gone, and with it, the idea that rights can be quarantined inside a zip code. The court's decision sent a thunderous message. You can't treat the Second Amendment like a privilege that gets smaller in cities and larger in rural areas. Your freedom to carry doesn't vanish the second you step off private land and onto concrete. For far too long, big city politicians have leaned on terms like community safety and public protection as political armor, using those phrases to deflect criticism while quietly dismantling individual liberty. They claim that densely populated areas demand tighter control, that more people somehow justify fewer rights. But this time, the court didn't fall for the bait. They saw through the tactic and called it what it really is: a violation of the Constitution disguised as public policy. This ruling took a direct swipe at one of the oldest talking points in the anti-gun playbook, the idea that high population equals high risk and therefore warrants stricter laws. The judges pointed straight to the Bruin decision and reminded everyone in power, loud and clear, that rights don't evaporate in the city. There is no historical precedent for disarming law-abiding citizens just because they live or walk among tall buildings. The Constitution doesn't carve out sensitive zones where freedom takes a back seat to fear. What this decision does is tear down the myth that cities operate under different constitutional rules. It sends a loud warning to lawmakers nationwide. If your policies are based on fear instead of facts, they will collapse in court. If you're pushing restrictions just because your city looks different on a map, then you better bring more than emotion. You better bring historical precedent and sound constitutional reasoning, because the courts are done tolerating lazy arguments. This wasn't just a win for one man or a rebuke of one statute. This ruling lit a fire that could ignite legal change from coast to coast. What started in Pennsylvania is about to ripple out across the country. Why? Because once one court rules that something like Section 6108 doesn't pass constitutional muster, it opens the floodgates. Every gun owner stuck under a city-specific restriction now has a fresh legal pathway to challenge it, and that's going to make a lot of urban governments very nervous. For years, cities like New York, Chicago, Los Angeles, and San Francisco have operated under the belief that they could write their own rules, as if urban geography gives them the authority to trim down the Bill of Rights. But here's the reality. The Constitution doesn't bend for traffic, crime rates, or population density. Your rights don't shrink because of how many people live near you. Liberty doesn't get rezoned. This ruling hands Second Amendment advocates something they've long needed, a tool that links gun rights directly to equal protection under the 14th Amendment. It's not just about keeping and bearing arms anymore. It's about whether you're being treated fairly under the law compared to citizens just a few miles away. And if the answer is no, then courts are going to have to reckon with that disparity. This puts pressure on lawmakers, too, especially those at the state level, to rethink laws that single out one city while leaving the rest of the population untouched. A patchwork of rules where your rights vanish at a city line. That's not sustainable anymore. What truly matters now is the precedent. When a court draws a firm line and says, "You can't go past this," others tend to follow. It sets a legal tone and forces a reevaluation of every ordinance built on weak constitutional ground. The path forward is clear: more lawsuits, more legal challenges, and increasing scrutiny of any law that treats city dwellers like second-class citizens when it comes to gun rights. The message is simple: governments can't keep dodging the Constitution just because it's politically convenient. The very document they tried to ignore is now boxing them in. This Pennsylvania ruling isn't just a local win, it's a national shift. It gives momentum to a movement that's been gaining steam for years, a movement that refuses to let urban boundaries define fundamental rights. From here on out, expect to see more judges asking tough questions, more laws being overturned, and more freedom restored. When the courts step up like this, the whole system begins to correct itself. So if you've stuck around to the end, I want to thank you. Staying informed and engaged is how we win these fights. Your voice matters now more than ever. So tell me, does this ruling give you hope for broader change, or does it leave you with more questions? Drop your thoughts down below. As always, I appreciate your time, your mind, and your passion for liberty. Until next time, stay sharp, stay prepared, and above all, stay free.